one concern that people have raised about court packing is that, say in 2021, Democrats will do it, and then the next time Republicans take control, they'll do it, and before long, we'll have a court of 55 people, and they won't all fit on one rostrum. I'm sure that's the primary concern. But what are some other reform proposals that are out there that might provide an off-ramp to that kind of escalation? I know one that you've written about involves 18-year terms for members, and I know there are some constitutional questions. Could that be done without a constitutional amendment? Talk a little bit about that, if you would, and I imagine we're about to get into some Article 3 minutia, folks, so strap in.
Well, Article 3 is very short, so I won't bore you too long, just simply because I can't. There's not much there. Historically, there's some historical evidence that says that the framers were kind of antsy to get back home, and they kind of gave up on Article 3. If you read it, it says that a Supreme Court needs to exist, and you can't reduce their salaries, and they have to serve while in good tenure. While in good behavior. And that has been translated to mean life tenure. Doesn't actually say life tenure. It actually doesn't even say judicial review if we want to get really technical about it. There's no mention of judicial review in the Constitution anywhere. So one of the proposals that's put out there is a constitutional amendment to bring back the filibuster, but on a constitutional basis. So to confirm a justice, you need 60 votes. And this harkens back to the original idea of the filibuster. The original idea of the filibuster was to foster compromise. And this kind of gets to Anna's question. So, why is this happening? I think it has a lot to do with the polarization in Congress, in the electorate in general, and that's translating now onto the court. Instead, what the filibuster slowly morphed into was, holding a seat hostage and just not doing anything about it. And so you get rid of it, and now you have a simple minority or a majority vote. So that's one proposal. One proposal that I'm fond of is a staggered term of years, so an 18-year term. And I posit that there doesn't need to be a constitutional amendment to enact this. So again, what Article 3 says is that they have to they can hold their office while in good behavior. And so it depends on how we define the office. If we define their office as a federal judge, then what we can do is, let's say we take the circuit courts, the lower courts, the appeal courts, and we use that as our pool of candidates. And the nomination and confirmation procedure happens normally, but the president has to select a judge from the circuit courts. As I think most of the short list that Trump is currently looking at are judges on the circuit court. They elevate to the Supreme Court for a term of 18 years, and when they're done, they go back to the circuit court. So long as we don't reduce their pay, I think that's actually consistent with Article 3's language. And what we would have then, and this is why I like it so much, because this is not a Democrat or Republican solution here. What it is it gives voters a knowable, foreseeable event. So every time they go to the poll to vote on a president, that they know that that president, the incoming administration, will have 2 seats to fill on the Supreme Court. And so accidents of history, accidents of health are kind of taken out of the equation, and we see less of this political jockeying that we see now. And it hopefully can restore some of the legal norms that are supposed to surround the court.